The other thing, there's a bunch of don'ts with closing arguments, right? You cannot voice personal beliefs. So we always hear this in our closings. Well, I think what should happen, the prosecution office, we really believe that, right? There's no thinking, there's no believing, all right? It's what the evidence shows, what the evidence did. You heard throughout the course of this trial. You cannot infuse personal beliefs. When you do, the other side can object, and it should be sustained. So you've got to think about it like this. What you think about the evidence doesn't matter, it's irrelevant, we didn't actually hear evidence of it. What you believe should happen also wasn't part of this trial, didn't hear it, so it shouldn't be part of your closing. Second thing is referring to evidence outside the record. The closing is supposed to be a reflection of everything that you did at trial. That's why we're looking at it this analytical way. That's why we're planning it, looking at the closing going backwards, right? You can't all of a sudden freestyle when you get up at closing and say, well, I didn't have time to put it on, but there's some other witnesses out there in the world who could really add to this case. You didn't see these exhibits, but there's a number of photographs that speak to exactly the issue he just brought up. No, you can't do it. If it wasn't part of trial, it's not part of your closing. And the strain on that and the issue with that is that whole reasonable inference part. We may have a difference of opinion. A fact comes out, like the shifting eyes on the surveillance camera. I can make an argument that my conclusion, my argument from it is a reasonable inference and was part of this trial. My opponent can say, hey, there's no testimony about shifty eyes, and that's not really part of it. We can argue about some of those things, but think about it. You have to, if you're stopped in the middle of your closing, objection, outside the record, objection, argues facts not in evidence, you better have something to say. Your Honor, this wasn't evidence because, and go into it and then go right back into your closing. So think about it. Everything that you want to make part of your closing, make sure it's a reflection or it's tied through a reasonable inference to what came out at trial. And this helps you plan which witnesses, which exhibits, what questions do I ask on cross. You can't vouch for witnesses, and what that means is you can talk about who they are and their background and what came out of their testimony, but you can't say, you know, Officer Jones testified at this trial. Is he really going to risk 20 years on the force and his job and everything that he stands for to come in here and lie to you? Of course not, right? That's vouching for a witness. That's you trying to put your views to the jury, right? That's you trying to say this is why he has to be believed and taking away the jury's ability to believe the witnesses it wants to believe. You say he had 20 years on the force. You say that he investigated this case from beginning to end. You say that he followed up with witnesses, and here's what he said. Those are facts. You can't say you have to believe him because of this. That's vouching for a witness. And a lot of cases, particularly criminal cases, are overruled on that basis when it comes out in closing. The golden rule. We got a bunch of golden rules. I'm not talking about the religious one. I'm talking about the jury, putting the jury in the place of a victim or party, right? This is the #1 law and order violation that happens, by the way, and in movies. Every time you think it's a really, really good argument that you heard in Law and Order, guaranteed they either violated some of these rules, but most of the time it's the golden rule, right? How would you feel if you were sitting at home and you were the babysitter and you heard the door open in the back by a crashing window? You'd be scared, wouldn't you? Now I'm putting the jurors in the place of the victim, and I can't do that. Can't put them in the place of the victim, can't put them in the place of a defendant, right? So the defense attorney similarly can't stand up and say, imagine you're at a poker game with your friends, and all of a sudden cops barge in, and they arrest you, and they throw your face down on the table. Can't do that either. You're putting the jurors in the place of the defendants. Now we can get at it. You can get at similar stuff, but you have to craft it around the edges. You can basically say, talk about the facts and talk about them in a first-person way so we feel like we're experiencing that story. I can make it a first-person account that you feel like you were there. I just can't tell you to be there. And I certainly can't tell you to pretend like you're the victim or pretend like you're the defendant. Last one is, there's always parts of trial that are carved out. The #1 one that happens in mock trial and trial ad with criminal cases is you can't talk about punishment in most jurisdictions. Most jurisdictions you can't say, and the real thing here is why you have to return a not guilty verdict is, this guy can't go to jail. Well, you're talking about penalties now. They're only deciding guilt versus not guilt, right? So we're not talking about some of these things. Happens in civil cases a lot too. If you read the background of these things, sometimes a lot of them damages are a separate phase of trial. We're just saying whether there was damages, whether there was injury under a negligence claim. We're not talking about the extent of the damages. So you want to go into hospital bills, all of a sudden you're talking about and arguing about something that's not before the court. So know what's before the court, and usually in criminal case, penalty phase is always not. You have to consider all the stuff you're going to know before you step up for closing. You're going to know how the law shakes out because you're going to settle under instructions. A lot of times they're going to be read. You're going to know all the evidence because the exhibits are already in and you've checked them. The witness transcripts are already done. They've already testified, they've had the directs and crosses and recrosses and redirects, everything. You also know, more importantly as it relates to this theme and theory, what happened in trial, how it shook out, how close to your version did it come, what do you have available to you now as it relates to giving that closing that you planned all along. And I gotta tell you, it works all kinds of ways. Sometimes it works out a lot better. You plan it, and you get to closing, and you're like, it got even better than that because their witnesses got on the stand and lied even more than I thought they were going to. Or they called witnesses that I didn't even expect and they ended up helping my case. Sometimes it gets better and you have more to work with. Sometimes what you planned got chipped away in motions in limine with the evidence, got chipped away with evidentiary rulings through the course of trial, got chipped away with witnesses not saying what you thought they were going to say, or being adversely impacted by cross-examination of your opponent. So it changes, and it changes sometimes because you knew it was going to change, but it changes other times of things outside of your control. So you have to have a real pulse of what I thought was going to happen and what I thought I was going to be able to say. And now, with what's happened throughout the course of this trial, what version we're dealing with and what I'm now able to say. And if you kind of have it planned out from the beginning and know where you're going, you can shift those things on the fly and you can have it be a true reflection of what happened at trial. If you don't have a pulse of that and you're like, yeah, we'll see where we are at the end of the trial and then I'll argue then, I guarantee it's going to be a mess because you didn't plan it out from the beginning and it's going to come off as unorganized, unedited.